3 years ago on January 6th, a mob attacked the U.S. Capitol. I know because I was there. I was there as rioters roamed the Capitol, thousands of them, as they were beating on the doors of the House chamber, as they were breaking glass to get in. Thank God for the Capitol Police that day. They protected us. They were bear sprayed and gouged and beaten in order to protect us. I left the chamber that day with a Republican who had ripped a wooden post out of the ground to protect himself. That mob was egged on by a president of the United States, Donald Trump, who couldn't accept that he'd lost the election and for the first time in history sought to remain in power. We need to make sure that never happens again.
Today, Chairman Jim Jordan has convened a hearing to take action against someone he says ignored a congressional subpoena. Today, Jim Jordan says that failure of this witness to appear was, quote, in blatant disregard of Congress's oversight role. Today, Jim Jordan says we must respond because, quote, he didn't show up to testify, unquote. And I say, bravo. Jim Jordan is finally ready to take action against Jim Jordan. This amendment would amend the contempt resolution and provide the form of the resolution that the Committee on the Judiciary would recommend to the House of Representatives, citing Robert Hunter Biden and Jim Jordan for contempt of Congress, pursuant to this report as follows. Resolved that Robert Hunter Biden and Jim Jordan shall be found in contempt of Congress for failure to comply with a congressional subpoena. Now, I know the chairman wouldn't want an ordinary citizen to be treated differently than a member of Congress. So let's run through some of the facts. On December 22nd, the Select Committee of Congress investigating a violent attack on the Capitol requested that Jim Jordan provide information for the committee's investigation, knowing that Mr. Jordan was a percipient witness to some of these events, had conversations with those involved in planning efforts to overturn the election. On January 9th, Jordan responded to the Select Committee's request with a letter refusing to comply. On May 12th of 2022, the Select Committee subpoenaed Jim Jordan, along with others, for deposition testimony as part of our investigation into the January 6th attack. On May 27th, Jordan failed to appear for his scheduled deposition before the Committee of Congress. On May 31st, the Select Committee indicated that Representative Jordan should appear for deposition testimony no later than June 11th. But Representative Jordan once again did not appear before the Select Committee on or before the June 11th, 2022 deadline, and he was referred to the Committee on Ethics. And so today we can remedy this situation. We can show some consistency if we're going to hold Hunter Biden in contempt for not showing up before the committee when he's offered to come and testify publicly. But if we're going to hold him in contempt for that, then surely we would hold Jim Jordan in contempt for his failure to appear before Congress. So this amendment would simply add Jim Jordan's failure to appear before Congress, his blatant disregard of congressional oversight, to use the words of the chairman himself, and remedy this by including him in the contempt report referring to prosecution for potential prosecution for contempt of Congress. And I would urge everyone's support. And with that, I'm happy to yield to any of my colleagues.
Yields back. Gentleman from California, Mr. Schiff is recognized. And then we'll go to Mr. Ryan.
Mr. Chairman, once again, we hear an effort to reinvent January 6th, this time as people expressing peacefully their disagreements with the government. January 6th was not a peaceful expression of differences with the government. It was a massive, violent attack on the Capitol with the object of overturning a free and fair election. Mr. Jordan cut off debate on my amendment to hold him in contempt, so we couldn't discuss what his role was, why he was subpoenaed, and whether he should be held to the same standard as a private citizen. And while he said quite erroneously that he was not required to testify either because he took issue with the object of the investigation or because the speech and debate clause, as Representative Lofgren pointed out, that does not apply to subpoenaing a member of this body. Let's remember who did step forward, and let's ask ourselves not why he was compelled and refused, but why he didn't volunteer to come forward, why he was unwilling to share his information, why it was even necessary to subpoena him. After all, so many others did their constitutional duty. Republican Speaker in Arizona, Rusty Bowers, talked about how he was compelled by his oath, by his faith, by the Constitution, to do his constitutional duty, to refuse the former president's entreaties to overturn the election. And he showed his devotion to our country and the Constitution by coming and testifying. Jim Jordan would not. Brad Raffensperger, the Republican Secretary of State in Georgia, did his constitutional duty both to protect the vote in Georgia, to ignore the former president's demands that he find 11,780 votes that didn't exist, but also to come and testify, to share with the country what he knew, but not Jim Jordan. Cassidy Hutchinson, a staff member at the White House, showed extraordinary courage to come forward, showed her devotion to her country and Constitution, and came forward and testified, but not Jim Jordan. Capitol police officers who were beaten and gouged that day, they came forward and testified, but not Jim Jordan. White House counsel, Republican White House counsel, came forward and testified, but not Jim Jordan. And lest we forget why the committee wanted Jim Jordan, let's look at our referral to the Ethics Committee over his failure to come forward for guidance as to why we wanted his testimony. Representative Jordan was a significant player in President Trump's efforts, we wrote. He participated in numerous post-election meetings in which senior White House officials, Rudy Giuliani and others, discussed strategies for challenging the election. Chief among them claims that the election had been tainted by fraud. On January 2nd, 2021, Representative Jordan led a conference call in which he, President Trump, and other members of Congress discussed strategies for delaying the January 6th joint session. During that call, the group also discussed issuing social media posts encouraging President Trump's supporters to march to the Capitol on January 6th. An hour and a half later, President Trump and Representative Jordan spoke by phone for 18 minutes. Yes, we wanted him to come testify about what he discussed with President Trump for 18 minutes. And no, Jim Jordan has never told this body why he was unwilling to tell the country about that conversation in the run-up to a violent attack on the U.S. Capitol. Or why he spoke with White House staff about, as we wrote, the prospect of presidential pardons from members of Congress. He was unwilling to say why he thought pardons from members of Congress might be necessary. And today, he's unwilling to tell us why there should be a different standard for a member of Congress who is subpoenaed than for a private citizen, and why the standard for a private citizen should be so much higher. My colleagues on the other side of the aisle say that's not a germane question. We love to hide behind germaneness when we really don't want to answer the root of the matter. And the root of the matter is, why is Hunter Biden's failure to appear worthy of a criminal contempt, but the chairman of the Judiciary Committee's unwillingness to comply with a congressional subpoena gets nothing more than a shrug? That's really the question before this committee today. And so far, there is no answer. I yield back.
Gentleman yields this amendment.
Thank you, Mr. Chairman. This amendment would add the Bipartisan Background Checks Act of 2023, authored by Republican Brian Fitzpatrick, to the underlying bill. This would provide universal background checks. We live in a state, live in a country where you can go into a gun store, you can be a felon, you can have a serious mental health issue that should disqualify you from obtaining a weapon, you can have a domestic violence restraining order against you, and you can seek to purchase a gun and you can be refused. But you can leave that gun store, you can go outside, you can buy that same weapon off the back of someone's truck. Or you can buy it online. Or you can buy it at a gun fair. It makes no sense to have a situation in this country where you can be refused because you failed a background check when you go to a store, but you can leave the store and buy the same weapon in the parking lot. That makes no sense to anyone, except perhaps the NRA. We don't have to live with the constant scourge of gun violence. We don't have to live every day just a phone call away from getting terrible news that someone in your family has been killed. Like so many families, my wife and I got a call from one of our kids about a shooting not far from campus. He was fine. Thank God he was fine, sheltering in place, but so many others have gotten much worse calls. And they're going to continue to get those calls if we don't do something about this. And the terrible shame about gun violence is it's not like we don't know what works. We know universal background checks work. We know an ban on assault weapons works. We know a ban on extended ammunition clips would work. We just have lacked the political will and courage to get it done. My constituents want universal background checks. This amendment would provide universal background checks. Your constituents, my friends across the aisle, they want the same thing. Americans overwhelmingly want truly universal background checks. Now, I realize the NRA doesn't want it, and so this puts all of us in the position of, are we going to vote for our constituents, or are we going to vote for the NRA? Well, I'm voting for my constituents. I'm voting for people in my home state of California who are sick of the constant scourge of gun violence, who are fed up with a Congress unwilling or unable to do anything about it. It makes no sense to have a system where you walk into a store and you're refused a gun because you're a felon, and you can go outside and you can buy the same gun off the back of someone's truck. That makes no sense. This amendment gives us a chance to change that. Gives us a chance to do something about this terrible, all-too-American problem of mass gun violence and everyday gun violence. Can we please do something? Protect the lives of our family and our neighbors. Protect the lives of people in their churches and their synagogues. Can we please just do something basic? Something simple, something universal, something that makes sense. I urge support of the amendment, and I yield back.
Gentleman yields back.
I withdraw the point of order.
Gentleman withdraws a point of order. Who seeks recognition? Gentlelady from Wyoming.
Move to strike the last word.
The gentlelady is recognized.
And I think that we've already covered the purpose of this bill and why it is needed, and the fact that we're talking about law-abiding citizens who both those in the military as well as those in non-traditional living arrangements. It's called the Travelers Gun Rights Act of 2024. We need to focus on what the purpose of the bill is. Anytime that a Democrat starts talking about universal background checks, you know that it's just another effort at gun grabbing and preventing people from being able to exercise their Second Amendment rights. I think that the bill is very clear. This is just another effort to prevent us again from being able to, a certain segment of our population, a certain segment of our law-abiding population from being able to exercise their rights. There are already laws in place for people who are straw purchasers or who are failing to follow the current gun laws. And instead of creating more laws, we should simply enforce the existing ones that are on the books and actually hold criminals accountable. With that, I urge rejection of this amendment and a yes vote on the underlying bill. Thank you. And I yield back.
The gentlelady yields back. For gentleman from New York. For New York, what purpose does he seek to be recognized?
Strike the last word.
The gentleman's recognized.
Mr. Speaker, I rise in support of this amendment. It is a terrible exception that you can buy a gun from anyone who's not a licensed dealer with no background check. Anybody can get the gun. Any bank robber, any serial murderer can walk in and ask for a gun, no questions asked. That makes no sense at all. From a private seller, that's what I said. From a private seller, not a licensed gun dealer. That makes no sense at all. This country has more gun deaths, I think 45 times as much per capita as any European country, because of loopholes like this, because of obeisance to the NRA. This is a modest amendment. All it does is say you have to have a background check, the same background check you'd have if you bought a gun from a licensed gun dealer, if you buy a gun from an unlicensed gun dealer. Why could anybody object to that? I urge adoption of the amendment, and I yield to Mr. Schiff.
I thank the gentleman for yielding, and I do want to respond to my Republican colleagues' comments. First of all, when you say any time a Democrat offers a universal background check amendment just because they want to take away people's guns, this is actually language written by a Republican from Pennsylvania. But even if it weren't written by a Republican, what about the rights of a middle school kid or an elementary school kid to go to school and not be gunned down with an assault weapon? What about their rights? What about the rights of worshipers in their place of faith not to be gunned down because someone could evade a background check by buying it at a gun show or buying it off the back of someone's truck? What about their right to life, to liberty, to the pursuit of happiness? Does that get no weight at all? And all we are asking is that people go through a background check before they acquire a record. Is that too much to ask for that child's life in grade school? Or that worshiper's life in church, or a moviegoer's life in the movie theater? Is it too much to ask that we make sure that people aren't circumventing the law by making background checks truly universal and not just a fractured system in which there are an infinite ways to avoid any kind of scrutiny? I don't think it's too much to ask, and I think we need to consider the rights of every American, including gun-owning Americans, not to be gunned down in their everyday lives because someone evaded a background check by buying the gun at a gun show or buying it online. It doesn't seem too much to ask to take this simple step if it's going to save so many American lives. I yield back.
And I yield back.
Gentleman yields back. Who else seeks recognition? Gentleman from Georgia, Mr. Johnson.
Thank you. I rise in full support of this very common sense amendment. I'll note, being from Georgia, that when I go home from the airport, I'll take the highway on home, and along the highway, the interstate, there will be billboards advertising for the next gun show coming to Georgia, coming to the metropolitan Atlanta area. And so I've had the opportunity to actually go to the gun shows, and I've been to the gun shows on the north side of town. I've been to the gun shows on the south side of town. And in every gun show, I see young urban residents purchasing guns from gun dealers, from licensed gun dealers, and also from unlicensed gun dealers. The tables will be set up in the gun show. There will be licensed gun dealers, and right next to the licensed gun dealer, an unlicensed gun dealer, and the setups are the same. I mean, you got tables, display cases. You can't really tell the difference, but the people there who come to make the purchases know the difference. And they will go to either a licensed gun dealer if they're legit, if they themselves are legitimate, and if they're not, then they make their way to the unlicensed gun dealer who's carrying the same wares as the licensed dealer, and they make their purchase from the unlicensed gun dealer. And then they walk out, and then they commit, those guns are used to commit crimes in urban and suburban areas that I represent. And those guns also make their way up here to Washington, D.C., and to other places with tighter restrictions on guns. And I don't know why we have a system of licensed gun dealers. I mean, there had to have been a reason why we originally licensed or we originally set up a regime whereby gun sellers had to be licensed. There was some usefulness in that setup, but the NRA came along and voila, a loophole inserted to allow unlicensed gun dealers. That undercuts the reason why you would have licensed gun dealers. The reason or the rationale for licensed gun dealers still exists today, and we need to go back to that system. We need to close this gun show loophole that allows for gun sellers to sell guns to anybody without a background check. It just simply leads to where we are today, which is too many firearms in the hands of too many people who should not have them. And with that, I will yield back.
Gentleman yields back. Who seeks recognition? The gentleman from New Jersey, Mr. Van Drew.
Just quickly on guns, you know, it's interesting to me that the areas where we have the most problems tend to be some of the areas that have the most strict and prohibitive legislation, laws, and rules dealing with them. I mean, I don't know what we don't understand, but we keep creating more laws, more rules, more regulations for those that are legal owners. Now, here's the deal. It's not the legal people that we have to worry about. We have two issues with guns. The first issue is that we have a real mental health crisis in this country. And I honestly believe, sincerely, part of that is due to the breakdown of the family, due to the stress and problems that exist in today's modern society, and just a lack of the basic values that we've held for so long. You know, when you look at these mass shootings and some of the horrific things that happen, almost all of those individuals put out in one way or another cries for help. They let people know. There were reports to the FBI, there were reports to others, and yet nothing happens so often. That's where we need to do better. And then the second issue is the rule of law. The rule of law. You know, when I was in the state senate in New Jersey, and a nice person, and I'm obviously not going to say who it was, they were just passing another rule and another regulation and another law going after law-abiding, peaceful gun owners. And, you know, she was trying to convince me that this was a good thing to vote for. And I think we had a good and thorough discussion about it. But towards the end of it, she said, you don't understand, this person who did this, who was a criminal, was using a legal gun. She said the only difference was they scratched the numbers off the gun. It wasn't a legal gun. That's what we have to do. We need the rule of law. Those that would steal guns, those that would get them in an illegal way is where the concern should be. What's happening to our urban areas, the lack of respect for the law, the complete decay of so many of our cities and the increase in the crime rate, it's got nothing to do with the individual man or woman that goes target practicing, that goes hunting, that uses guns in a legal way. And it just gets old. So we keep passing more and more laws prohibiting more and more legal people that do no more harm, and yet we don't do enough. And in fact, we're doing less. You know, in so many of these areas, quite frankly, with liberal prosecutors, they let people out quicker than we ever did before. They commit a crime, they turn around, they're right out. I've talked to police officers in Washington, D.C., and they said it's to the point where it's told if it isn't a homicide and we don't hear gunshots, we don't even do anything anymore. But even when it is, They're turning people out more quickly. We all saw in D.C. when they wanted to actually let people out more quickly and reduce the penalties for carjacking. We realized in Washington, D.C., that we had an FBI agent whose car was jacked. We had staff people working for senators in Congress whose cars were carjacked at gunpoint, that we've had others, Congress, members of Congress, including a Democrat congressman, that were carjacked. It's all because we don't have the rule of law. We could fix this real easily. Better mental health and better rules and laws dealing with those who are illegal, those who are criminals. All those carjackers, they didn't go and get their gun registered. They didn't go through a process where they got qualified to carry a gun, as legal people do. So, what we'll probably do is make it harder for, good American people that aren't doing anything wrong to get a gun or to get ammunition. That's not the problem. I yield back.
Gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Just in response to my colleague's comments, as someone who has been carjacked and was carjacked by people who were 17 and 19 years old and had obtained illegal guns because our streets, our entire country is awash in guns that people are making in their homes because we're not regulating ghost guns that are coming up the iron pipeline. There's a term for it that our law enforcement talks to us about. The iron pipeline from the southern states up the I-95 corridor and even smuggled on Amtrak to come up to cities like Philadelphia, to be trafficked to children who then use them in carjacking. So I do think we need to pass some laws. You say we've passed a lot of laws. In fact, they haven't become laws. We need more legislation that can be enforced to make sure that when people exercise Second Amendment freedoms, which I don't think anyone on this side is saying we got to take everyone's guns away, but we are saying that if you're going to own a gun, you need to do so responsibly. That's what my family grew up with in a rural area. I assume that Ms. Hageman's family had responsible gun ownership. They weren't just throwing them out on the street or selling them for a couple $100 to whoever happened by. I think we need to make some distinctions here. It is not a black or white issue.
Will the gentlelady
Like
yield
every
for a
other.
moment?
No, I'll yield back to the chair.
Gentlelady yields back. Gentleman from Wisconsin is recognized.
Move to strike last word.
Gentleman's recognized.
I would yield my time to the Congresswoman from Wyoming.
Thank you. Move to strike the last word.
Gentlelady is recognized.
All right, let's go back to what the purpose of this bill is, because we've moved way far astray. I'm going to say this again. H.R. 1508, the Travelers Gun Rights Act of 2024, is a simple and straightforward bill that allows active duty service members, their spouses, full-time RV travelers, and those without a permanent resident or address, such as what we've described in rural America, to legally purchase firearms with either a private mailbox or a post office box number. We are now addressing an entirely different set of legal and criminal issues that has nothing to do with the question of whether that subset of people should be able to use a private mailbox or a post office box number for their address to purchase a gun. And unless you can point to this particular subset of people being the perpetrators of the crimes that you have described, which I'm sure that the 17-year-old and 19-year-old involved in that crime that you have described were not living in RVs, were not the spouses of active duty service members, and were not themselves active duty service members, the same can be said for the people involved in the other types of criminal acts that you have described. Unless you can say that those are the ones that are the subject of this bill, then everything you have described is entirely irrelevant to the topic at hand. This is not about yet another effort at gun grabbing. This is about making sure that a particular subset of law-abiding citizens are able to exercise their Second Amendment rights. With that, I would yield to the gentleman from New Jersey.
Thank you. I appreciate it. And you're right. You're obviously right about what you just said. And unfortunately, it was addressed on the other side. And you know, a problem I have, I guess it's from being from New Jersey. I can't let stuff go sometimes. But this is a subject of the bill. It's a good bill. It's appropriate. And I guess my point would be, again, those people who are service members, those people who are living in rural areas or live in RVs or whatever the case may be, are not the problem here. And I believe that's what the gentlelady is pointing out. And in general, the gun issue is not the problem, is not those who legally obtain guns. There's no reason that these people can't obtain guns as well just because of their particular address. And I know in some rural areas, even in my part of New Jersey, there are folks that have P.O. boxes that are great individuals and great human beings and don't deserve to be discriminated against in this case. I yield back.
Gentlelady yields back, and the gentleman from Wisconsin yields back. Who seeks recognition? Chair recognizes himself for 5 minutes. I do think there's one place where this amendment is relevant to the underlying bill, and it is where the same people charged with enforcing this, which would be the federal government, are the same people who wrote it, and it's abundantly clear they don't understand rural America. The exceptions that are written allow for a federal government on interpretation of state law, whether it's farming law, whether it's domestic violence law, whether it's hunting, fishing, trapping laws. And it puts a tremendous burden shift on a citizen exercising their Second Amendment rights to qualify that they have the ability for a temporary transfer. First of all, there are no shooting galleries in North Dakota. I think you'd get beat up if you said the word shooting gallery in North Dakota. The vast majority of people who do these types of things in rural America do them in rural areas, on farms, on different places. But the audacity or the ability to temporarily do this with hunting, fishing, farming, ranching, and to be, in order to engage in your lawfully protected Second Amendment activity, you have to essentially vouch for compliance with every single state law that you may come into contact. I'll give you an example. North Dakota, you have bifurcated farmland. So if you are engaged in farming and you borrow your truck to your ranch hand that has a gun in the back, and you drive to town and have breakfast before you go check cows south of town, when you leave the ranch, you're probably engaged in farming. When you get to the place, you're probably engaged in farming. But when you stop at that town with that gun in the back of your car rack, as you borrowed the ranch owner's hand, you're not engaged in farming or ranching. You're having breakfast. And to say that the federal government has primacy in prosecution over that state law in all of these different situations that, by the way, happen every single day in rural America, every single day. But it's more draconian than that, and it's more nefarious than that, because the people I know are lawful gun owners. It doesn't matter if you're a hunting buddy or a hunting guide or a fishing guide or a farmer or a rancher. When you have the ability to the federal government to come in and prosecute based under intent by a transfer for temporary transfer, in utilizing state law to incorporate a federal charge, you are just going to see these things not happen because these people want to follow the law. They are law-abiding citizens. And so when I read these things and I read how the exemptions are written, and I appreciate my friend Mr. Fitzpatrick, and I appreciate people who care about this, but is it abundantly clear to me that the vast majority of the people who write these exceptions for rural America have never been anywhere farther than wherever their local city park is. And until we recognize that this is not how life occurs in places where I live and where Ms. Hageman lives and where Mr. Johnson lives, which is the same reason for the underlying bill, by the way, then you are dealing with issues that simply do not work in huge swaths of this country. And for that reason, I would oppose the amendment and I would support the underlying bill. And with that, I yield back. Question occurs on the amendment from the gentleman from California. All those in favor say aye. Aye. All those opposed say nay. No. In the opinion of the chair, the noes have it.
Mr. Chairman, on that, I request to record a vote.
A roll call vote has been requested. Clerk will call the roll.
Mr. Jordan, Mr. Issa, Mr. Buck, Mr. Gates, Mr. Biggs, Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes.
The gentleman from California is recognized.
Mr. I want to ask you about some of the differences between the facts involving President Biden and President Trump. But before I do, I want to refer back to your opening statement in which you said that you did not disparage the president in your report. But of course, you did disparage the president. You disparaged him in terms you had to know would have a maximal political impact. You understood your report would be public, right?
I understood, based on comments that the Attorney General had made, that he had committed to make as much of my report public as consistent with legal policy and legal requirements.
And you could have chosen just to comment on the president's particular recall vis-a-vis a document or a set of documents, but you decided to go further and make a generalized statement about his memory, didn't you?
Congressman, I could have written my report theoretically in a way that omitted references to the president's memory, but that would have been an incomplete and improper report, and that it did not reflect my analysis.
You could have written your report with comments about his specific recollection as to documents or a set of documents, but you chose a general pejorative reference to the president. You understood when you made that decision, didn't you, Mr. Herr, that you would ignite a political firestorm with that language, didn't you?
Congressman, politics played no part whatsoever in my investigative steps.
But you understood nevertheless,
the words
didn't you,
that I put in my report.
Mr. Herr, you cannot tell me you're so naive as to think your words would not have created a political firestorm. You understood that, didn't you, when you wrote those words, when you decided to include those words, when you decided to go beyond specific references to documents? You understood how they would be manipulated by my colleagues here on the GOP side of the aisle and by President Trump. You understood that, did you not?
Congressman, what I understood is the regulations that govern my conduct as special counsel.
And those regulations
required me to write a confidential report for the Attorney General,
which you knew would not be
explaining my
confidential.
decision, and that is what I did, Congressman. I
Mr.
followed
Herr,
the rules.
You knew it would not be confidential.
I followed them.
You knew it would not be confidential, didn't you?
Sir, the regulations required me to write a confidential report explaining my decision to the Attorney General.
Which you knew would be released.
It was up to the Attorney General to determine
you understood it would be released, did you not?
Would be released consistent with DOJ policy.
You understood it would be released. You understood it would be released.
I understood from the Attorney General's public comments that he would make as much of my report public as he could, consistent with legal requirements and DOJ policy.
And you also understand DOJ policy that you are to take care not to prejudice the interests of the subject of an investigation, right?
That is generally one of the interests that DOJ policy requires that prosecutors respect.
And it was your obligation to follow that policy in this report, was it not?
It was also my obligation to write a confidential report for the Attorney General explaining completely my
what
decision.
you did write was deeply prejudicial to the interests of the president. You say it wasn't political, and yet you must have understood. You must have understood the impact of your words. You must have understood the impact of your decision to go beyond the specifics of a particular document, to go to the very general, to your own personal, prejudicial, subjective opinion of the president, one you knew would be amplified by his political opponent, one you knew that would influence a political campaign. You had to understand that. And you did it anyway. And you did it anyway. And let me just go to some of the differences here between the president's conduct and Mr. Trump's. In the superseding indictment, on page 3, it says that Mr. Trump suggested that his attorney falsely represent to the FBI and grand jury that he did not have documents called for by the grand jury subpoena. You didn't find anything like that with respect to Mr. Biden, did you?
Congressman, I do not have the Trump indictment in front of me, but I need to address something that you said in your prior question. What you were suggesting is that I needed to provide a different version of my report that would be fit for public release. That is nowhere in the rules. I was to prepare a confidential report that was comprehensive and thorough of an explanation.
What is in the rules, Mr. Herr, what is in the rules is You don't gratuitously do things to prejudice the subject of an investigation when you're declining to prosecute. You don't gratuitously add language that you know will be useful in a political campaign. You were not born yesterday. You understood exactly what you were doing. It was a choice. You certainly didn't have to include that language. You could have said, vis-a-vis the documents that were found at the university, the president did not recall. There is nothing more common. You know this, I know this. There is nothing more common with a witness of any age when asked about events that are years old to say, I do not recall. Indeed, they're instructed by their attorney to do that if they have any question about it. You understood that. You made a choice. That was a political choice. It was the wrong choice. Mr. Chairman, I yield back.
Gentleman yields back. Gentleman from Arizona, did special counsel wish to respond to that final question?
Yes, Congressman, what you are suggesting is that I shape, sanitize, omit portions of my reasoning and explanation to the Attorney General for political reasons.
No, I suggest that you not shape your report for political reasons, which is what you did.
That did not happen, Congressman. That did not happen.
Gentleman yields back. The gentleman from Arizona is recognized for 5 minutes. Chair recognizes the gentleman from California.
Mr. Attorney General, we appreciate your being here. We appreciate how you have led this department with integrity and discipline and your enormous public service. I appreciate your willingness to sit through this endless cascade of false allegations and conspiracy theories and innuendo. The chairman began this hearing with the dramatic statement that justice is no longer blind. By that, he means that justice is no longer objective or impartial, that it is suddenly now a respecter of persons in the wrong way. That is, it will distinguish between people based on their position. But of course, the chairman's real problem is that justice remains no respecter of persons. That you can be the former president of the United States, but if you commit crimes, you'll be held responsible. That's his problem. That's the problem of all my Republican colleagues right now, and that is they're about to nominate a convicted felon. And they don't know how to cope with that. They don't know how to cope with the justice system that, in fact, treats Donald Trump the same as it would any other citizen. And so they have to push these conspiracy theories that they know are patently false. And they try to run over you with questions they won't let you answer, because their whole arguments are utterly insupportable and destructive of our justice system. They care more about this convicted felon than they do the country. I have to say I'm pleased and a bit surprised to see that the flag in this committee is still flying right side up, because they want to turn it upside down, even as they want to turn our justice system upside down. Let me address the conspiracy theory of the day, which is somehow President Biden, through your department, has convicted Donald Trump in Manhattan in an effort to weaponize justice against the former president. So let me just ask some basic questions about this phony conspiracy theory. Did you appoint Alvin Bragg to be Manhattan DA?
No.
Of course not. He's elected. Did you select the jury in that case?
The judge selected the jury.
Did you select the judge in that case?
No.
No, of course not. The judge was randomly selected. Did you select the jury in that case?
No.
The jury was actually selected by Donald Trump and his attorneys. Did you reach a verdict in that case?
No.
Did you instruct the jury in that case?
No.
Did you tell the prosecutor what charges to bring in that case?
No.
This was 12 ordinary New Yorkers who weighed the evidence and found Donald Trump guilty of 34 felonies. And instead of celebrating the fact that in this country, an ordinary group of jurors, an ordinary group of 12 people can still adjudicate a case involving one of the most powerful people in the country, no, they would denigrate the whole system. They would tear it down. In the service of this convicted felon, they would tear everything down. They would tear the house of this democracy down around them. They say it's unprecedented to bring charges against a former president. You're damn right it's unprecedented. We've never had a president of the United States who was making hush money payments to a porn star and then falsifying business records to cover it up. Yeah, that's unprecedented. We've never had a president withhold classified information and then obstruct the investigation. That is unprecedented. We've never had a president incite a violent attack on the Capitol. That is unprecedented. And you know what else is unprecedented? The fact that so many leaders of that party are perfectly fine with all of that. In their headlong pursuit of power, they're perfectly fine with that. They're going to nominate a convicted felon as their presidential candidate. And they have another conspiracy theory, which is when a search was executed of the president's residence in Mar-a-Lago, they went in, as the president said, locked and loaded and ready to take him out. Yet another dangerous falsehood. And your dedicated public servants at the Justice Department are having their lives threatened because of the irresponsible actions of people on this committee and in the Senate and elsewhere who would endanger the lives of those committed to enforcing law and order, even as they claim to be a party of law and order. Mr. Attorney General, I am grateful for your service, for your withstanding all of this. We will get through this because of people like you and the honorable public servants at the Justice Department. Mr. Chairman, I yield back.
The gentleman yields back. The chair recognizes the gentleman from Arizona.
Thanks, Mr. Chairman. Mr. Attorney General.
Yields back. The gentleman from California is recognized.
I want to begin by quoting the jury in the Manhattan hush money payment trial. Guilty, 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 guilty. This was what the jury pronounced unanimously on every count. My Republican colleagues don't really contest Donald Trump's guilt. This is the fascinating thing. Their argument is essentially he should never have been prosecuted, or they falsely claim it was a political prosecution, or they falsely claim it should have been a misdemeanor, not a felony. But they don't contest, not really, that Donald Trump was making hush money payments to a porn star to hide their affair from voters. What they're really saying is they're more than comfortable nominating and electing as the President of the United States someone making hush money payments to a porn star. The party formerly of the moral majority is now, I suppose, hoping to fashion some kind of immoral majority to reinstate Donald Trump as president. The presidency, the most powerful office in the world, and not the most powerful because of the size of our military, but because of the power of our ideas. And what is the animating idea of a Trump presidency? It is dictatorship. It is power at all costs. And this is also tragically the animating idea of the Republicans on this committee. Power at all costs. What else can explain what it would profit them to give up their political soul but a world of power? Ambassador Eisen, I want to ask historian Eisen a question. Is there any period of our history that sheds light on what we're going through today? Have we ever seen one party or the other so completely abandon oath to the Constitution, commitment to truth, commitment to decency, so willing to tear down the rule of law, our institutions, our justice system, anything that gets in the way of power? Have we ever seen anything like this?
Three periods come to mind, Mr. Schiff. The first is the founding period, and in particular the ferment between the Articles of Confederation and the Constitution, when the founders and the framers, famously the Federalist Papers, a passage you know well, worried about that in that period of instability, a tyrant would arise. That was resolved by one of the fortunate accidents, not just in American history, but I dare say in the history of the world. George Washington's establishing the tradition of peaceful transition that Donald Trump ultimately broke for the first time in our history. Number two, the Civil War period when we had those within who also proclaimed that they would not accept American rule of law. And that period of divisiveness is also found in the post-Civil War era, the decline of Reconstruction, that assault on our constitutional system that became the Jim Crow era. Those are three precedents. We see other dangers, including here in Congress, the period of McCarthyism. Donald Trump represents the most grave danger to this country, at least since the end of Jim Crow, very likely since the commencement of the Civil War, and perhaps since the founding of our nation from within.
Thank you, Ambassador. Mr. Chairman, I'll yield back.
Gentleman from California withdraws a point of order who seeks recognition. Gentleman from California is recognized.
Mr. Chairman, much as I don't like certain parts of the Mazur decision, it clearly applies in this case, and the committee is required to engage with the White House in order to seek an accommodation over materials held by a private party, as they were in the Mazur's case, and seek to resolve this with the White House. So I would ask unanimous consent that we enter into the record your correspondence to the White House.
Without objection.
Seeking to engage them to resolve this. And I thank the chairman for not objecting. Can you produce that correspondence to the White House asking for accommodation on these materials you sought by this subpoena?
First time they reached out to us was 2 days ago.
Yes, and of course the author expressed the concern that these materials may implicate interests of the executive. I think that was weeks ago. But having admitted without dissent your correspondence to the White House, can you produce that for us where you have sought an accommodation, where you've sought to work this out with the White House? Can you share that with us since that is now part of the record?
Well, I thought you had it. You wanted to enter it into the record.
I do. I presume that, knowing your responsibilities, you have sought to engage the White House. So,
Mr. Chairman, point of order.
Produce the
recognized for point of order.
I think a unanimous consent request to submit something to the record is where the person who's asking for the floor is the proponent of submitting information that member has. I don't believe it's appropriate to ask a unanimous consent request to engage in a colloquy over discovering information or obtaining information from another member of the committee.
Great, and that's why I said that no objection to the unanimous consent request. If the gentleman from California wants to talk about that and present it to us, God bless him. He's allowed to do it. So it's 5 minutes.
I would like clarification from the chairman. Does this mean that there is no correspondence from you to the White House seeking accommodation on this material?
We've had all kinds of correspondence with the White House on this broad subject relative to the Zwanitzer and the letter we got 2 days ago. We've not corresponded with the White House yet. If we will, we may. That's a decision we'll make.
And you have not corresponded with the White House seeking accommodation ever since the author who you are subpoenaing and seeking to hold in contempt articulated the view that there was executive interest and potential privilege over this material. You haven't sought to engage over the weeks since you received that communication?
We have not engaged with the White House since the letter on the 25th of this month, 2 days ago.
And prior to that time, did you engage the White House in an effort to obtain these materials?
All kinds of engagements with our counsel and counsel.
I'm talking about
the Justice Department and White House with our counsel over the last several months relative to the special counsel
this subpoena, Mr. Chairman. Did you engage with the White House at any time in the last several weeks since issuing this subpoena, the one you want to hold this witness in contempt for? Did you ever engage with the White House in an effort to accommodate, an effort to reach an agreement, an effort to prevent this from having to be litigated? Did you ever write any correspondence, make any call to the White House seeking to engage, seeking to get these materials that you're seeking from the author instead from the White House. Did you ever do that, Mr. Chairman?
We're seeking documents from a private individual who I might add tried to destroy the evidence.
I guess the question is, I guess the answer is no.
Since
I guess the answer is no.
The answer is since 2 days ago, I'm not
asking the question about since 2 days ago, although nothing
That's when they first raised the concern.
Nothing prevented you from writing a letter within the last 2 days or reaching out to the White House before this.
Now you want me to be clairvoyant and read the White House's mind and write a letter before they tell us something?
Nothing prevented you from seeking these materials from the White House
is known
for months, Mr. Chairman. For months.
I'm not a mind reader.
I thank you for making a very clean record for any court that will look at this.
The gentleman from North Carolina said
an accommodation
months ago the White House could have raised the concern, and they didn't.
These documents. Because your first move, of course, is to go right to contempt. Ironically, of course, for a chairman who was in contempt of his own subpoena.
Point of order, Mr. Chairman.
We're still waiting for you to testify and meet the obligations of your own subpoena, Mr. Chairman. But nevertheless, I appreciate you're making such a clean record for any court in this case that you have never sought an accommodation, never written to the White House, never called the White House, never had a communication with the White House in order to obtain these materials as part of an accommodation. Thank you for that very clean record for the court, and I yield back.
Gentleman yields back. Who seeks recognition?